Hello, this is Aaron Gauthier, Judge of the 53rd Circuit Court for the counties of Sheboygan and Presque Isle here in beautiful northern Michigan. I know it's been a while since we've uploaded one of our Ask the Judge videos. We had a question on the channel about contempt of court a while back. And this was the question. How do you feel about the ability for a judge to hold someone in contempt? From a citizen's point of view, it seems the judge has power to accuse, prosecute, judge, and sentence without a trial. Should contempt cases be tried by other judges in an actual court setting? So I thought I'd do a quick video explaining the basis for the contempt power, the different kinds of contempt hearings, and the difference between civil and criminal contempt. The contempt power is rooted in the inherent power of the judiciary as an institution and as the third branch of government. The Court of Appeals has explained it this way. The primary purpose of the contempt power is to preserve the effectiveness and sustain the power of the courts. The power to hold a party in contempt is inherent in the judiciary. In that case, the Court of Appeals also explained that the contempt power is set forth in various statutes, but this merely reinforces the common law inherent power of the court. So there are some statutes in Michigan describing various conduct that constitutes contempt of court. Things like not showing up for court, not showing up for jury duty, refusing to testify, disobeying a court order or a bond condition, or non-payment of child support or other fines. These types of contempts are considered indirect contempt because the contempt occurs outside the direct presence of the court. This really includes everything except disruptive behavior, which we'll discuss in a bit. A hearing for indirect contempt is started by either a show cause or a bench warrant. A show cause is an order directing the person to appear in court and show cause why they shouldn't be held in contempt. A bench warrant, on the other hand, is a warrant issued by a judge for the police to arrest the person for the purpose of bringing them to court for a contempt hearing. In either way, someone has to file an affidavit requesting the show cause or bench warrant, explaining what the person allegedly did to be in contempt of court. Now, the judge whose orders were disobeyed also presides over the contempt hearing. The question posed on our channel was whether this is fair. Should the judge have the power to accuse, prosecute, and judge someone without a trial? Good question. The answer is that, at least for indirect contempt, there are several procedural protections to ensure fairness. For example, there's a right to a hearing, and the contempt must be proved beyond a reasonable doubt. Also, the person accused of contempt has the right to a lawyer, including a lawyer at public expense if jail is being considered. They also have the right to present a defense and witnesses of their own, and a right to appeal to a higher court. Essentially, a person accused of contempt has all the procedural protections of a criminal case, except there's no right to a jury trial. The United States Supreme Court held in 1968 in a case called Bloom v. Illinois that there is no right to a jury trial as long as the contempt punishment is less than 6 months in jail. In Michigan, the maximum penalty for contempt is 93 days. So although there's no jury trial and it's not in front of a different judge, there are many protections against unfair or abusive use of the contempt power, or at least for indirect contempts of court. There's also something called direct contempt of court. Direct contempt is committed during the court proceeding itself in the immediate view of the judge. An example would be disrupting a court hearing. This is described in Michigan statute as, quote, disorderly, contemptuous, or insolent behavior directly tending to interrupt the proceedings or impair the respect due to the court's authority. Direct contempt may be handled summarily, with no separate hearing necessary. If possible, the judge should give the person an opportunity to be heard, of course. For example, hold them in contempt, but allow them to make a statement if they have anything to say for themselves before announcing the punishment. But sometimes that isn't possible. The Court of Appeals says that the key is that the contempt power is being used to restore order in the courtroom and to ensure respect for the judicial process. And the U.S. Supreme Court has said that due process is not violated by a summary contempt where the behavior is an open threat to the orderly procedure of court or a flagrant defiance that undermines the court's authority. So for direct contempt, there is not much process involved, but that's a necessary and inherent power to protect the court's authority and effectiveness to do its job. Interestingly, in Michigan, if a judge does not immediately hold someone in direct contempt, but waits until after the hearing and then wants to hold them in contempt for behavior that happened during the hearing, the Court of Appeals says that that contempt hearing must be held in front of a different judge. The reasoning is that the need of immediate restoration of order is no longer present. So those are the types of hearings for contempt. What's the punishment? That depends on whether it's considered criminal or civil contempt. This does not, however, refer to the underlying kind of case where the contempt occurred in. Rather, it refers to the purpose of using the contempt power. Civil contempt applies when someone refuses to obey a court order and the court is coercing their compliance. So in civil contempt, a person can cure the contempt at any time by simply obeying the court order. Civil contempt penalties, for example, can include a fine per day until the order is obeyed, or in extreme situations, jailing a person until they obey the court order. When that happens, the person must hold the key to their own jail cell, meaning as soon as they obey, they're released. So civil contempt isn't really punishment, but coercion. Criminal contempt, by contrast, applies to a past action, like failing to appear, or violating a bond condition, like using drugs or having contact with the victim of a crime. The purpose of criminal contempt is to punish that past behavior. The Court of Appeals has specifically held that criminal contempt is not really a crime itself, it's just a quasi-crime, meaning that you have the same protections, but it doesn't result in an actual criminal record. Now in Michigan, criminal contempt generally is punishable by a maximum of 93 days in jail and or a fine of $7,500, or up to. There are some other specific contempt punishments, for example, violating a personal protection order or failing to pay child support, but those specific penalties usually involve less jail or less of a fine, or both. Sometimes online, you may see videos of judges holding someone in contempt for 93 days for disruptive behavior, and then giving them additional contempt sentences of 93 more days consecutively, even adding them up, stacking them on top of each other to add up to hundreds of days in jail. Under Michigan law, this is not permitted. Contempt sentences would run concurrently or at the same time, not consecutively. And remember, if it added up to more than 6 months in jail, the person would have the right to a jury trial anyway. So as you can see, the contempt power is a serious one, but it's necessary to protect the authority and the effectiveness of the third branch of government. There are some procedural protections, but not as much as a full jury trial. So judges should be very careful about how they use this power. It is contempt of court, after all. It's not contempt of judge. So ego should have nothing to do with it at all. The sole purpose and consideration in any contempt is to ensure compliance with court orders and to have a safe and dignified courtroom environment for everyone to be heard. I hope this helps answer some of the issues about the contempt of court power. If any of you have some more specific questions about this or another topic, please drop them in the comments. Also, check out our other videos on our channel on court system topics, as well as videos of our actual court hearings. And you can subscribe to the channel and enable notifications if you want to be alerted when we go into session. Thanks for watching, and I'll see you in court.